So there's been a change on punitive damages. So this came straight from the Supreme Court, and this is gonna protect business owners in here. So there's been if you don't know what punitive damages are, there are some areas of law where a judge can say, your behavior's been so bad that I'm not just gonna give the other side money, I'm gonna give them extra money from you to punish you. You see this a lot with insurance companies, because sometimes they're right for that. But when to get punitive damages, you can't just sue for it. I can't just say, Paul, I think you're a bad guy, I'm gonna sue you for punitive damages. You can't start a lawsuit that way. You file a lawsuit for whatever the actual cause is, and then you can go to the court later and say, there's an aggravating factor, I wanna add punitive damages. You go to a hearing, and you say, here's all my evidence. If I can prove this up, should I get punitive damages? And it's undisputed, uncontested hearing. The judge will just look at what you got and say yes or no. There's been a federal doctrine, and a doctrine that has protected the parties in the public sector, that says, that's fine, you can sue them, you can add punitive damages, but once you do it, there's discovery, and that's the kicker. So it adds financial discovery. So what that is if I sue Paul because he's a bad contractor, I can't say, by the way, give me all your bank accounts. I wanna see what you have in your bank, I wanna see all this other stuff. That's protective information. But as soon as punitive damages are added, it's no longer protected. I can get that stuff because I need to make sure you can pay me in the event this punishment is awarded. So what the state Supreme Court has said is that immediately becomes an appealable issue. And why this matters for you guys is anytime I've ever had a case where I file a lien and then I file suit to foreclose a lien, the homeowner's attorney is gonna counterclaim for fraudulent lien. Punitive damages are an element of a fraudulent lien. Do I have to say slide on this? I do. So if you have a lien, it can be fraudulent in two instances. One is you're just basically guessing at the amount you're writing in there. It's either you put down a number, I'm owed $10,000, and that number was calculated with gross negligence. You didn't really know what you owed, you just did something, or it was willful. You overstated your lien because you're like, screw this over, I'm gonna file this lien, and I'm gonna get my money, right? And the other part is,
you say that for work you didn't do.
for work you didn't do, that's right. So you lien and you haven't completed the work yet. If you do those, it means your lien is in fact fraudulent and you are now exposed to punitive damages. The owner moves to get the punitive damages. You can now appeal in that moment, instead of waiting to the end of the case to appeal that decision. So it's a way to protect yourself from basically having to disclose all your financial information to a customer who, once they have all your bank information, whatever it is, God knows what they're gonna do with it, right? But it will cause an appeal, and appeals can last several years. So that's something to think about too, is if you're suing an owner, it can slow things down.